you.
My Lord, trailed that we were going to go next to the October.
Yeah.
Before we do that, my Lord, I want to just re-anchor ourselves, if I could put it that way,
Of
in
course.
what the Environmental Principles Policy Statement involves doing. And if we just go to that document first, that's at tab 2 of the supplementary, at tab 1 of the supplementary bundle.
Thank you.
From page 4. I'm just going to reiterate what's said first of all on page 6 is the approach is to ensure that the environment, nature and environment are proactively designed into the policy making process. On 7, that that policymakers are encouraged above the large heading to identify the potential environmental effects and use the principles to inform and influence the design of the policy. And then at 10, under the large heading, 4th line down, they should consider how adjusting the design in the early stages of policy development could result in greater environmental protection. And then at 13, under integration, as set out in the environment, integration is the principle that environmental protection should be integrated into the making of policies. This means that policymakers should look for opportunities to embed environmental protection and/or enhancement across fields of policy. And then in the 3rd paragraph down, application of the integration principle. Applying the integration principle involves considering whether the policy has the potential to cause a negative environmental effect which could be avoided, minimised or reduced through alterations to the policy in proportion to other policy aims. So when one is complying with the duty in the process of developing policy, what the policy is telling you to do is to consider ways that you could alter to reduce environmental harms in the formulation of the policy. So it's a process very much guided towards the development of the policy, the process of making the policy and ensuring that it avoids or minimises environmental harms. A point was taken against me at the very outset of this morning about the judicial, the statement of facts and grounds not making this point. Can I just take my lords to paragraph 38, which is Core Bundle 198.
Core Bundle 198.
Yes, that's paragraph 38. So these, the court will recall that the claim was brought and then amended because of the way in which matters evolved after the claim had been brought in December. And so this relates to the, this is part of the amended grounds, paragraph 38.
Yeah.
The EPPS assessment document which the Minister was asked to consider misled the Minister as to what the EPPS requires. The EPPS requires consideration of whether environmental harm could be avoided, minimised or reduced. Under integration, the analysis given to the Minister by officials was at each stage of the policy development process, the proposal has been designed with the environmental protection as their central objective. The future home standard, complemented by the WMS, is intended to significantly reduce carbon emissions generated by new buildings. There's no consideration of avoiding, minimising or reducing the harm of the WMS policy, and the defendants filed no evidence nor any documents that the Minister considered revising the wording of the WMS policy or otherwise. It instead pleaded that he was only asked to consider whether the decision to publish the WMS should be revisited. The advice also conflates the future home standard. So there are other points, but
yeah, well, that was the point you finished on just before lunch. Yeah.
Yes, but just to answer the point that it wasn't taken in the pleadings, that's there. And then we then come to the October assessment, which is at tab 2, page 21 of the supplementary bundle. And if my lords want to read it, it's one page. That's probably the quickest way, and then I can just
start. Sorry, starting where?
Well, I recommend the first paragraph and the
44.
Sorry, my lord.
Sorry,
page 21 of the supplementary bundle.
Sorry, I was in the core bundle.
Sorry, page 21 of the supplementary bundle. Tab 2. That is.
Oh, this document. Yes.
Yeah. This is the prior submission to a minister. sets out that section 19 is about to come into force in the first sentence. So, my lords, my submission is that doesn't comply with the duty to have due regard in making the policy to the EPPS. It doesn't attempt to consider how to reduce the harms through consideration of alternatives. It doesn't consider how to influence the design of the policy in accordance with the principles set out in the EPPS. It doesn't attempt anything like what we see in the pro forma of actually drawing focus to bear on each of the environmental principles, or refer indeed to any of the text of the policy at all.
When you say policy in that sense, you mean EPPS?
Yes, the duty is to have regard to the EPPS in making the policy, and I submit this document does not illustrate that in making the policy, due regard was had to the EPPS. Now.
Yeah, thank you.
And so that informs then the scope of the duty that was on the minister when in December she was required to consider the duty. She didn't, we know that, but what would have been required of her is informed by the fact that there has not been consideration of alternatives that feed into the design of the policy. And so that would have been for the minister at that stage. And so it also therefore informs what happens when we get the analysis done in February, March. Because at that stage, having due regard to the EPPS in the making of the policy, to do that with rigour and an open mind, that rigour is brought to bear upon the content of that duty, which is the making of the policy. So the question has to be asked again, what alternatives have we looked at? How have we integrated the EPPS principles into the design of the policy so as to reduce the harms? And so at none of those stages is the duty complied with. That's the submissions in the round on all three stages.
And what do you say to the Secretary of State's proposition that it refers to the environmental protection policies and talks about the negative and positive aspects?
But that's not sufficient to discharge the duty.
Not
because
sufficient.
When one looks at what the policy involves, it is more than weighing up the pros and cons. Or it is different to weighing up the pros and cons. It's about analysing how to reduce the harms and to allow that to inform the design of the policy in question.
Does it consider the alternative of allowing local authorities to set policies which require greater energy efficiency than the future home standard?
Does what consider that, my lord?
Does this document consider the alternative? Because you said that it should consider alternatives.
Yes.
I'm wondering what alternatives it should have been thinking about. Does it consider the alternative of local authorities setting policies above the FHS?
Not sufficiently in accordance with the duty.
Well, does it do it? Does it do it at all? And then is the criticism that it doesn't do it enough?
Well, I think what my lord is directing the question 2 is the final sentence of the second paragraph. The policy contained in the WMS.
Well, I had in mind the preceding sentence as well.
Yeah, is that any energy efficiency improvements above the FHS would return marginal carbon saving benefits compared to the cost uplift of doing so. Yeah. So, but what that doesn't do is consider how to inform the design of the policy. There's nothing that complies with the policy instructions there.
Thank you.
I mean, there's myriad alternatives that one could see that would be relevant to that consideration, but there's not a single one considered. It's not said, for example, what if we encourage local authorities to set standards as high as possible towards net zero? There's not an and so when we get to the end of the process and we see the way the Minister is asked to address the evaluation of the policy, what we cannot see from that evaluation in the March document is how the conscientious, rigorous, open-minded application of the EPPS principles, including to look at alternatives to inform design, would have influenced the shaping of the policy. So that applies also to the November-December changes. We don't see any alternatives to those. Those just get written in. And there's no advice given to the Minister on those changes or to any alternatives to them. Yet we know that back in July, less stringent options were on the table. They just haven't been subjected at any point to an EPPS.
That's option
analysis.
one. That's option 1.
Yes. Well, and indeed option 2 itself, as formulated in July, was less stringent than what emerges through the October and then the final form. So, to help make this submission, can I take my lords to paragraph 48 of my learned friend's skeleton argument for the respondent? Because there is actually, despite the vigorous debate around the principles, some common ground on these. Paragraph 48. The respondent says, on retrospectivity, there is common ground that it will not generally be appropriate for the Section 19(1) duty to be met through post-adoption regard to the EPPS. It is likely by that stage that opportunities to integrate environmental principles into decision-making would have been missed. The purpose of Section 19(1), as confirmed by the EPPS, is that the principles are used to inform and influence the design of the policy. However, that does not mean that post-adoption consideration will never be capable of discharging the duty. So, up to there is in essence as a statement of the legal principles, common ground. And then we do differ over what is meant by the final sentence, where my learned friend says, if rigorous and open-minded consideration is given to the EPPS in reviewing a policy, that's capable of discharging the duty. But that's imposing a different standard from common law understanding of the duty that doesn't really get to the nub of what the Section 19 duty is about, because it's not simply enough to be rigorous and open-minded. You have to be rigorous and open-minded relevant to the nature of the duty in question. So that's rigorous and open-minded about considering how the design of the policy can be informed through the EPPS process.
Could one say simply rigorous and open-minded in the application of the EPPS?
Yes. And so just to put that in a specific context as an example of the facts in this case, we don't have any indication from the ministerial submission in March what the rigorous, open-minded application of the EPPS would have involved to the cross-departmental thinking in November, December. So we know that alterations were made to the policy and there must have been thinking behind why those went in. None of those options or alternatives are analysed, nor indeed any others. And so that's not compliant with the duty. Now obviously I anticipate from the judicial interventions that there's an inclination to consider whether those changes are really material or substantial, but that wouldn't be a complete proper focus on the duty, because the duty is not just to consider the changes that in fact happened, but to consider how those changes were arrived at. What was the process that informed the design of the ultimate policy? And that may well have involved discounting greater or lesser changes as well. But we don't get any of that in the EPPS. There's just a simple fait accompli presented to the minister, and then that's evaluated against various criteria. And that misunderstands the nature of the statutory duty in my submission. And we can see that in truth, that's what the Secretary of State understands the duty to be from pages 88 to 89 of the bundle, of the supplementary bundle. This was the pre-action response, and what the Secretary of State said would happen at page 89. Three lines down, we accept that Minister Penn, who took the final decision on the 2023 WMS in December 2023, had not been provided herself with an EPPS analysis. We're proposing to provide an updated EPPS analysis on the 2023 WMS to Minister Penn and ask her to consider whether or not changes should be made to the 2023 WMS in light of the EPPS analysis. That recognises the true nature of the Section 19 duty and the proper application of it in the subsequent analysis. That's not in fact what happens, and we've seen that from the document.
Where was this letter sent to the Good Law Project Limited with the two claims? It's not
no, they have a legal a solicitor's firm. It's called Good Law Practice, so they were representing the claimant at the time.
Okay.
And so how that filters back, my Lord's question earlier, is scales in paragraph 33, Roman 3, as to the error the judge made. We say that the judge failed to appreciate the significance of the definition of making policy, which includes developing and adopting, and not just focuses on adopting and revising. And so her error was in failing to see the importance of the focus on developing policy, both in statute and in the policy itself. So, my Lord, that makes the legal argument. I'm just going to come back to one point on the inchoate FHS. In the court below, we actually had all the consultation documents on the Future Home Standard. They haven't, for bundle management reasons, been all reproduced. But the Future Home Standard is still subject to consultation on options. So there are two differing options. Some of those are referred to in the submissions on behalf of the Essex planning officers, so that's where we can see what those are. But there's still an inchoate nature to it, in that there isn't a policy that is the Future Home Standard to which.
Can I just understand the submission? Are you saying there's not a draft FHS to which the WMS could be applied at all?
There's two options under.
Yeah, but when we had this discussion earlier on, I got the impression that the consultation going on now was about technical matters as opposed to matters of principle.
Can I look at the documents and give an accurate answer, because off the top of my head, the honest truth is I can't answer
Fair
it as
enough.
precisely as my Lord would wish, and
That's fair enough.
and
Thank
come
you.
back on that.
But otherwise, look, you're suggesting we look at the Essex Planning Officers Association.
Yes, which concerns this point about the differences in the standards that are applied.
So as we haven't had this, does it condescend to things like solar panels on roofs? And
Yes,
things like that?
and that's a new feature that is going to be brought in when it comes in. That's just been announced. So that's a new evolution of the future.
And Bowsers for grey water underneath houses or not?
That level of detail I'd have to look.
No. I just only out of interest.
Yeah. Rather than guess, I'll find the details of it and hopefully put something short.
Thank you.
So I'll come back to the points on the detail if I may, but I was asked to clarify that specifically.
So was there anything you wanted us to take from the Essex Planning Officers Association?
Sorry, let me just find that.
I think it's divider 6 in the core bundle, if it helps.
Thank you. Yeah, the place in which it touches on this is this difference between TER and SAP, which are
So you're on page.
Page 4 of the submissions.
So 110.
Yeah.
Paragraph 6.
Yes. And paragraph 8 sets out the consultation on the standards that are going to be in place.
Ending up by saying that the SAP will no longer be used to
Yes.
compute the TER,
Yeah.
which sounds a bit technical.
Anyway, that's that point for that. So, my lords, I'm going to, unless there's anything further on ground 1, move on to ground 2.
Thank you.
Thank you. So ground 2 is that the judge erred in terms of her interpretation of section 1 of the Planning and Energy Act 2008. Can we go straight to the section itself, which is in the bundle tab 2? And subparagraph 1, a local planning authority in England may, in their development plan documents, and a local planning authority in Wales in their local development plan, include policies imposing reasonable requirements for, and there's A, proportion of energy used in development to be from renewable sources, B, proportion of energy to be from sources in the locality of the development, and C, development in their area to comply with energy efficiency standards that exceed the energy requirements of building regulations. In 1C, energy efficiency standards means standards for the purposes of furthering energy efficiency that are A, set out or referred to in regulations made by the appropriate national authority under or by virtue of any other enactment, or B, set out or endorsed in national policies or guidance issued by the appropriate national authority, Energy requirements in relation to building regulations means requirements of building regulations in respect of energy performance in conservation and of fuel and power. And then 5 and 7 are also important. 5, policies included in the development plan documents by virtue of subsection 1 must not be inconsistent with relevant national policies for England. And then the relevant national policies are, and C, national policies relating to furthering energy efficiency in the case of policies included by virtue of subsection 1C. And so just to go back to 1.4a, the powers conferred by subsection 1 has effect subject to subsections 5 and 7 and to section 19 of the Planning and Compulsory Purchase Act 2004. The 2004 Act we have at tab 1 and page 15 of the bundle. And subparagraph 1a is the important one for present purposes. Development plan documents must, taken as a whole, include policies designed to secure that the development and use of land in the local planning authority's area contributes to the mitigation of and adaptation to climate change.
And when was that inserted?
Well, I think footnote 2 says the Planning Act 2008.
Yes, so that
Which I think was received royal assent on the same day as the Climate Change Act.
my lord is
They went through Parliament simultaneously, virtually.
my lord's had to consider those acts on a number of occasions.
Yeah, I think so.
So yes, the Planning Act and the Climate Change Act
Thank you.
are pair in 2008. Then
Just whilst we're on, have you got
Yes.
any more on the 2004 Act?
no,
No, could I ask one question?
yes,
We're told in subsection 4 of the section 1 of the PEA that the power is subject to section 19, and section 19 is all about the preparation of
Yes.
policies. Is it right to say that the remaining provisions of that part of the 2004 Act, for example, section 20, independent examination, apply to policies included in a DPD under section 1 of the 2008 Act? Do they have to be examined like all the other policies in a draft local plan? Or put the question the other way around.
Yes.
Is there a carve-out so that anything a local authority comes up with pursuant to section 1 doesn't have to go through the independent examination process?
no,
No, that's what I would have thought. Indeed, the WMS proceeds on that basis.
yes,
So before you even get to the WMS, the requirements of soundness and so on
yes,
in the 2004 Act, as explained in the National Planning Policy Framework, will apply to such a policy.
yes.
Okay, thank you.
And in the, in fact, in the first Rights Community Action case about the West Uxbridge District Council's net zero garden village, the policy was for that, it was an area policy saying for this garden village, all buildings to be built to a net zero standard, was subject to examination by 2 inspectors
Yeah.
who recommended approval of the plan subject to main modification of get rid of the net zero policy
Yes.
because that's inconsistent with the 2015 WMS.
They found the policies unsound.
Found it unsound on that
Yeah.
premise.
Yeah.
That's what Rights Community Action then challenged.
Yeah.
Was the report prior to adoption. There was a section 113 interesting issue on that, but prior to adoption, and that's what Mrs. Justice Lieven upheld in the first challenge, was the quashing of that decision.
Yeah.
And that very policy is now going back next week.
Yeah, but
to-
that doesn't detract, as I understand it, from your understanding of the statutory framework,
Yeah,
that any such policy is subject to examination for soundness.
it is. Yes.
So long as you examine that question soundly.
Yes.
Right.
Yes.
Thank you.
And We endorse the submissions for the intervener, and in any event make the same submissions, that section 1 has to be read having regard to its context and purpose. There's voluminous authority on that proposition cited, but one example is Bennion tab 37, which says there are times when the language of an enactment will provide a clear answer to the issue before the court, and other times when it does not. In cases where it does not, one might expect the courts to pay particular regard to the purpose of the enactment. So our submission as to what section 1 is doing, and this is consistent with my Lord's observation that it slots into the examination process, is putting beyond doubt what powers the local authorities had. And that includes in subsections 1A, B and C. Subsections 1A and B, as the court below noted, relate to what had been called the Merton rule, whereby local authorities, including Merton, had come to set policies on proportions of energy in their area being from renewable sources or local sources. So it put that Merton rule on a statutory footing, but it had been understood to be lawful, and a number of policies had been implemented. And we've set out in the skeleton, and it's in the bundle, at supplementary bundle, page 96, that the Planning Policy Statement 22, in force in 2004, stated local planning authorities may include policies that require a percentage of the energy to be used in new residential, commercial or industrial developments to come from on-site renewable energy development. So it was already part of policy. That's 1B at the time this act was passed.
Did you say page 96 of the supplemental bundle?
Yes, my lord.
Okay, sorry, just catching
That's
up.
PPS 22 from 2004.
And we look at paragraph
8.
8.
Yeah.
Are we concerned with 1A and 1B, or are we primarily concerned with 1C? And what's
Yes.
1C
Yeah.
mean?
So, my submission is, in all three respects, the provision is making clear what was already a power held by local authorities in any event. So they didn't have an express articulation of it, but under their existing plan-making powers, they could have articulated policies to this effect.
So there was no need to enact this provision to give them the root power. It was happening anyway.
It was happening anyway, and this ensured that it put it on an express statutory footing where it would have been implicit before.
But we are just dealing with the interpretation of 1C. You're not relying on any implied powers or Section 1 of the Local Government Act or anything. We are down to interpreting 1C, aren't we?
Yes, well, we have made clear that the context is that.
Yes, I understand that, but
is that the power is there in any event, because that's relevant to the extent to which, in our argument, the Secretary of State can cut that power down. If the power is residual in any event, that affects the lawfulness of the policy that seeks to restrict the exercise of the.
Do we first have to read 1.1c and decide what that means? If it means X, and if you say there are some other implied powers that are broader, we'll have to look at those. But isn't the starting point to work out what 1.1c means?
Yes, we do need to do that. Yeah. Mm-hmm. So the other powers.
In doing that, maybe we also have to have in mind that if Parliament enacts a specific power on a particular area, that often replaces what might otherwise be a general implicit power.
Yes.
Because Parliament has specifically intervened.
Yes. So.
But then it goes back to my Lord's question about what it actually says. Yeah.
Just one other part of the statutory context is the Section 43 of the Deregulation Act was the outcome of a consultation by which it was proposed to repeal Section 1, but was never brought into force.
Is that
Well, is that
help?
a fair way of putting it? As I read the policy statements, government didn't give up the possibility of bringing it into force, but they said we shouldn't do so for the time being in the interim. They seem to have done that twice.
Yes, notionally, Section 43 of the Amendment of Planning and Energy Act 2008 could, I suppose, still be brought into effect 17 years on. That's I suppose notionally.
I think in 2019, when they decided upon the 2021 uplift to the building regs, they said then we're not going to bring in Section 43 for the time being.
Yes.
I paraphrase. Is that a fair understanding?
Yes.
Yeah.
I don't also understand how, at the moment, the fact that a minister could exercise statutory powers to amend an act under the Regulation Act, whatever it is, how that helps us deal with the first question, which is what does 11C actually mean?
Yeah. Addressing what it meant, or what it means, the former Written Ministerial Statement of 2015 set out the respondent's understanding of its meaning, which we say is appropriate. That's at the supplementary under 118.
One one eight.
118 is tab 22 of supplementary bundle.
This is the 2015 statement.
Yes.
Yeah.
And then on page 122, at the top of 122 sets out this deregulation bill and what it would do. And then 3 paragraphs down, the beginning, for the specific issue of energy performance, local planning authorities will continue to be able to set and apply policies in their local plans which require compliance with energy performance standards that exceed energy requirements of building regulations until commencement of amendments to the Planning and Energy Act 2008 in the deregulation bill. This is expected to happen alongside the introduction of the zero carbon homes policy in late 2016. Then,
Sorry, I thought you were taking us to this because it shows how the government interprets.
yes, so the government interprets at that point.
Sorry if I missed it.
Yeah, well, that local authorities enjoy the power to exceed energy requirements of building regulations until commencement of the amendments.
It doesn't tell us what those policies are and whether they're limited. And I'm puzzling as to how a ministerial statement helps in 15 helps us understand what a different body, the Parliament of the United Kingdom, meant in 2008. Is it a legitimate aid to interpretation?
Well, I'm not suggesting the court should be influenced. What I'm doing is setting out how the Secretary of State understood the policy in the 2015 WMS, and that was one in which there was no particular metric stipulated at that point for setting standards above the building regulations. And again, with the same caveat that I'm not suggesting that the court's bound to accept it, the government's response at tab 25 on the Future Home Standard 2019 consultation is set out, January 21, and at 2.39 on page 148. The final sentence on that page at 240 confirms the government wouldn't amend the 2008 Act.
Sorry, this is 148 paragraph
2.40, the final line.
That's going back to section 43 again
Yes.
of the 2015 Act. That's the paragraph I had in mind, yeah.
Yes.
Because this is in 2019, isn't it?
2021, it's response to the 2019 consultation.
Oh yes, quite right, big pardon. Yeah, it's the response. Yeah, thank you.
And then the next tab is the government response to, I've got 2 tabs on, 27. This is the April 23 consideration of the new Written Ministerial Statement, the one we're concerned with, and the policy background. So this is back in April 23, is set out at paragraph 1. The view there, the Planning and Energy Act gives local planning authorities the power to use local plans to set energy efficiency standards that exceed those required by the building regulations. So, in each of these places, the government took the view that the levels could be, the building regulation energy requirement levels could be exceeded in policies. There was no suggestion as to the role that national policy might play in relation to those powers. So there was no suggestion that the exceedance needed to be provided for in national policy.
Well, is it fair to say it was silent on that particular point either way?
Yes, but at no point does the Secretary of State suggest that Section 1 only enables local authorities to go beyond the building regulations to the extent expressly provided for in national policy.
But don't we really have to look at the words of
Yes,
Parliament, not what some very important government minister said at various stages?
Yes. So, if we go back to Section 1 then, my Lord, in answer to your prompt, what we've suggested is to make sense of what is a difficult provision, is that Section 1 limits the type of metrics or methodology for determining energy efficiency to those set out in national policy under Section 1(2)(b).
Sorry, limits the metrics or type of methodology?
Yeah, so that's the meaning of energy efficiency standards. That's what
To,
standards.
and it limits it, I beg your pardon, to those set out
In 1, 2, A or B.
So the metrics or methodologies,
That's
you still have to be something which are compliant with subsection 2.
Yes,
So they have to be set out in regulations
or
in national
laws.
policies issued by the Secretary of State.
Yes. So that makes sense. We say of the energy efficiency standards.
So metrics is somehow different from standards then?
No, that's what we're saying standards means. We're saying
The word standards means metrics.
all methodologies, yes. What it doesn't mean is energy efficiency requirements or levels.
But it doesn't mean the standard. It's the metric by which you can tell whether you've achieved the standard.
Yes, my Lord. Yeah.
Or the methodology.
Or the methodology. And that contrasts with the phrase energy requirements in section 1(1)(c). And that's about the level or percentage uplift, or the CO2 efficiency of a building, for example.
It looks as if energy requirements means the level that the building has got to achieve.
Yes, I agree with that. And that's our submission. So we've seen in the documents that there was a level at Code for Sustainable Homes, and then in 2021 there was a 30% improvement on that, and that the FHS will be a 75% improvement on energy efficiency requirements
In a sense, that's not surprising that it's referable to achievement by buildings, because they're to be found in building regulations.
Yes. Yeah. So the energy requirements refer to those uplifts. In this case, would be above the building regulation energy requirements, because that's what it's concerned with.
So the second part of 11C is the level that the building must achieve.
Yes.
And the first part is local authorities can have policies to comply with energy efficient standards that go beyond those requirements. So they use standards, not requirements, but they're saying they can go above the level required by the regulations.
Yes. But the standards are the methodologies by which you assess whether you are going beyond those requirements, because there are various different ways in which the energy requirements are measured. There are various different methodologies for measuring heat loss, etc. But those standards have to be set out by national policy or in regulations. You can't just use whatever method you want.
So can you give me an easy example that I could understand of something that would be permissible, which was a standard and not a requirement?
So one of the standards that we see referred to is TER.
Yes.
So you use TER because that's set out in national regulations or policy. And you say, according to TER, all buildings must achieve a net zero energy efficiency requirement as measured using TER. That's the way in which the, in a very simple form, the policy would work, but it's a lot more complicated than that when you get down to the way in which these standards operate.
I think the WMS illustrates what you're saying, because if a local planning authority wishes to exceed the draft FHS, for example, it can put forward a policy for examination, but one of the two criteria which is applicable, having got past viability,
Yes.
is that it should be expressed in TER terms.
Yes.
Using the standard, the SAP.
Yes,
Yeah.
and that, in the evidence, various local authorities have complained about that and said it's not a good method, but
Yes.
so be it. That's the Secretary of State's
Well, I was
choice
going to
on that
ask you
front.
about, since we've arrived at this point, a lot of the debate seems to be about, as you rightly say, about the rival merits of that methodology as opposed to the Letty method.
Yes.
And I've got some understanding of that. But the Letty method would be relevant in terms of Section 1 of the 2008 Act. On your reading of
Yes.
Section 1C, if it was specified in a regulation or policy.
Yes.
And it isn't.
Yes. So to that
It seems
extent,
to be a bit of a hollow debate.
yes, we're not particularly in this in the appeal. We're not concerned with it. In the wider world, there's a big debate about
Well,
it. But in this appeal,
That's why we're reading the witness statement from the Essex Planning Office Association.
yeah,
Insofar as it puts forward the relative merits of Letty, that would only be relevant if it was, on your reading, if it was a metric, which had been specified in a regulation or policy. And as I understand it, it hasn't.
as I understand it, that's right, my lord. But that's
Because if it had, there wouldn't be a Section 1 problem.
yeah. But so the Written Ministerial Statement, as it stands, restricts the standards that can be used to TER. That's what it says.
But on your reading of the statute, that's what the minister is allowed to do.
Yes, and I'm not challenging that bit.
No.
Yeah. So that element of standardisation that's achieved by the Written Ministerial Statement is unchallenged. It's not liked by some people, but it's not challenged here.
It's obvious. The judge below said that the statute wasn't that easy to understand. I think it's laid out in the Queen's printer. It's tolerably clear. So what we've got is a statutory power which put on a statutory footing what local authorities could do, but in actual fact it does contain some constraints.
Yes, as to the standards, certainly.
As opposed to any previous, general, broad, implied power.
Indeed, on that acceptable, yes.
Thank you.
The thing I'm struggling with is the way that the draftsman seems to have thought of this is that there are energy requirements in the building regulations. Buildings must achieve certain things. The Parliament was allowing a leeway whereby stricter outcomes, to use a neutral jargon word, could be required by local authorities. And they call that standards, in contradistinction to the energy requirements in the building regulations. But the standards have to be set out in national policies or guidance or regulations. So it seems to me as if the draftsman is thinking, well, they can go with the building regulations when that says what buildings have to do, but they can also choose one of a number of national policy guidance standards or regulation standards. But I'm not sure yet, firstly, the significance or meaning that you're giving to standards. I don't understand why metrics and methodologies is important and why you need a different word for standards. And you've still got whatever standards you have, they've got to be in the national guidance or regulations. So I'm trying to work out what thing is left for them to do which isn't within those definitions understood in that way. I don't know if that's clear.
Yeah, so the building regulations will set what energy efficiency levels have to be met.
Yeah.
Whether that's a heat loss measure.
You can't lose more than 20% heat if you can express it in that way.
If you can express it in that way, yes.
Mm.
Local authorities can set energy efficiency requirements that are greater than that. So
yeah, they can't lose 30% of. They can't lose more than 10% of heat would be stricter. Yeah.
Yes, or
provided that's in national guidance or policies.
No, and then but the way in which you measure it, so because there's all sorts of different methodologies, that has to then use the national guidance. That's the standards.
Sorry, so it's only the measuring. So there doesn't have to be something that says, there doesn't have to be a national document that says you can go to 10% instead of 20%. This 1.1c only covers the way in which you measure the higher standards that local authorities are free to choose.
That's what the statute says, yeah.
So let me just make a note. Yeah, thank you.
The contrary position, which the judge below took, is that the words that exceed energy requirements of building regulations is to be interpreted that only those requirements set by the Secretary of State are permissible. And we say that can't be wrong.
So you've used, forgive me, you've used the expression energy requirements.
Energy, sorry,
you meant presumably
energy efficiency requirements.
Well, energy efficiency standards.
No. Oh, sorry. Sorry,
Yes,
energy requirements is the right term. Sorry,
Yes.
it's in the second half of 1C.
There are three things. There's energy requirements in the building regulations.
My fault. Yeah.
There's energy efficiency requirements, which you can fix. And there are energy efficiency standards by which you measure the extra energy requirements. And that's got to, as I understand it, be in national guidance. But the energy requirements, the energy efficiency requirements that you fix as a matter of your local authority discretion is not constrained by the Act.
I'm not sure whether. Sorry, my fault. I'm confused.
Are we back to
in
help?
1C? There's energy efficiency standards and the energy requirements of building regulations.
Exactly. There are two concepts.
There's two concepts.
And we're back to 1.1c.
Yes.
If I'm keeping up.
Yes.
And your reading of energy efficiency standards is talking about metrics.
Correct.
And it's in that context you're going to tell us what the alternative Secretary of State view of energy efficiency, or sorry, what the judge was doing, which is broader than metrics.
Yes. So what the judge said at 70 was the distinction which Mr. Goodman seeks to draw between standards and requirements, and the narrow approach to standards, is not one reflecting the language of the statute. She rejects that there's any difference as between standards and requirements.
As I understand it, you're saying that local authorities can fix energy efficiency requirements that exceed the requirements in the building regulations.
Yes, they can require greater efficiency than the building regulations, using standards that are of a particular method.
Yeah. The standards have to be approved nationally, but the either 10% or 5% is for you, and the measuring of what's 5 or 10% has got to be approved nationally.
Yes, ma'am.
But where does the power come then in one? It's not derived from 11C, the power to develop energy efficiency requirements.
The power is in 1.1 that they can include policies in their development plan imposing reasonable requirements
For A, B or C.
for development in their area to comply with energy efficiency standards that exceed the energy requirements of building regulations. So,
And that's defined to be the ones that are in national guidance and policy. So if you're looking for them to have a power to fix something, whatever word you use to describe it, which they have the right to fix, not to choose between ones included in different national guidance, you've got to have a power to allow them to develop policies for meeting those energy efficiency, whatever word you want to call it.
yes. That's what I say the power does, is to allow local authorities to put policies in their plans that say, new housing, you can exceed the energy, you must, in policy terms, exceed the energy requirements of building regulations, applying these measures, these standards, these methodologies.
Just so that I'm being clear, I'm saying that you can have things in the policies under 11C, and I'm avoiding these words deliberately, if they're in regulations or guidance, and you said that's limited to metrics or whatever methodologies. If that's the case, I'm still struggling to find the source of the power in section 1, which allows you to include in your policies things to do with energy efficiency that aren't standards as defined.
Well,
Because the only energy efficiency things you can do under 11C are things which are in regulations or policy, national policies or guidance. There's nothing to say you can do things that aren't in national guidance or regulations, if you follow me.
yes.
That's my hurdle at the moment. That's where I'm stuck and I can't get over. So it's which words on the page show that you've got this power to do energy efficient things.
Well, the words are there. I mean, this is where we get to the difficulty of the drafting, is that it is difficult to put it together. And this is why we say you have to look at the purpose, and the purpose is to set this power. To exceed the energy requirements of building regulations. I mean, that's the thing that you can do with 1C, is say, as a matter of policy, don't build it to the minimum, build it to a higher energy requirement. A better energy requirement. That's what 1C enables, we say.
And that's why you say the judge was wrong at paragraph 70.
Yes.
Yeah.
69 and 70, isn't it?
And that's concordant with the way in which the Secretary of State has always understood it, which is why my submission it's helpful to look at.
Well, the Secretary of State doesn't really, in fairness, enter into this debate at all in the sources you've shown us. It's neutral one way or the other. I mean, what I'm trying to understand, I think it's on the same lines as you've been asked about. If we go to subsection 2, we have a definition of energy efficiency standards.
Yes.
And they're supposed to be set out in national regulations or measure or policy.
Yeah.
That you say that doesn't prevent a local authority from setting a standard because it only applies to a metric by which you measure achievement of the standard. I think that's what you've been saying so far.
I think that's what I've been saying.
Yeah. But if that's right, I think what my Lord is asking about is if you go back to section 11C and plug all that in, what they're being given power to do is to, on this reading of the statute, is to set a policy to comply with a metric or a methodology rather than a standard. So in other words, it's any part of a standard.
Yes.
By this way of reading the statute, one's excluded the possibility of setting us a standard. All the local authorities can do is set a metric. Maybe this discussion is being driven by this debate between LETI and TER, rather than looking at standard as a whole, I speculate.
Well,
I think that's, if I follow my Lord correctly, I think that's what we're seeking help on.
If the problem is that if standards is taken to mean a level of energy efficiency in the alternative hypothesis, then 1.2 sets that level of energy efficiency must be set out in regulations or set out or endorsed in national policies or guidance by the appropriate authority.
Yeah.
And so in that case, they can set policies that impose reasonable requirements for development in their area to comply with energy efficiency standards as defined in 1.2, in other words, as authorised in those policies set by the Secretary of State. But that then, if you go back to 1C, leaves the question, what does exceedance of the energy requirements of building regulations actually mean then? Because 1C is enabling you to go above the national regulatory standards.
No, it's the building regulations. If the building regulations say you must make sure that 20% of heat doesn't escape, and you've got a national policy that says it's really good to aim for 10% only, you could put the standard of 10%, which exceeds the standard in the building regulations of 20%, into your local policy. It's allowing you to select where there are relevant excess requirements, but it's not allowing you to create your own on this reading.
But only if it was set out or endorsed in national policies or guidance.
Absolutely. They don't have a complete freedom. They aren't limited to the building regulations. It's a narrower freedom. It's not they can fix whatever levels of energy efficiency they require, but they aren't limited, on one reading, to that set out in the current building regulations. If there's national policy or national guidance or other regulations, they can opt to put those into their local policy, so it won't just be a national guidance, it'll be part of their local policy, which is presumably relevant to other decisions that they take. That's one reading of it. It's a more limited freedom than perhaps people thought they were getting. A and B seems to be different because A and B seems to allow them a freestanding. We can choose the relevant proportion of renewable sources or low carbon energy from their area. But when you get to 1.1c, it's more constrained by the definitions in 1.2 is the argument against you, I think.
But then you could just stop 1c at standards. So on that interpretation, it would just say that they can set policies for development in their area to comply with energy efficiency standards, meaning standards for the purposes of furthering energy efficiency that are set out or endorsed in national policy or guidance. There would be absolutely no need to say that exceed the energy requirements of building regulations.
But isn't this to do with having local requirements that go further than the requirements fixed in the national building regulations?
Yes, the building regulations set the minimum.
That's the floor.
That's the floor.
And the question is the ceiling to be fixed by the local authority if it wishes, or is it only able to choose a variety of ceilings offered to it by the national government?
Yes, but you don't need the words that exceed the energy requirements of building regulations if all that is being done is to say you can set standards that comply with national policies as set out in 1.2.
But that's because it's a more limited. You can't set other standards. You can only set standards that exceed the energy requirements of building regulations. These are all limiting definitions. Your starting point is the only thing you're dealing with in 1C is where one set of things exceeds another set of things. But you can't do any old set of things, only the set of things approved in regulations or national policies or guidance.
Then my lord comes up against the difficulty that that construction is at odds with what everywhere is said is the purpose of the provision.
Well, everywhere except Parliament, yes. Yeah.
Which is, well, in Parliament. I mean, when we look at Hansard, it's the same.
We don't normally like doing that.
I understand we don't like doing that, but where it's ambiguous, we're permitted to do so, and Judge Below did.
If what you get is clear. But sorry, can you come back to what the purpose is? You were just about to say.
Well, the purpose is to permit local authorities to locally set energy efficiency requirements above building regulations.
Well, that's why the words are in there. They're not OTOs.
But
It makes it clear what the purpose is.
On the alternative interpretation that's being put to me, what this power is really doing is establishing the ability of the Secretary of State to limit the powers of local authorities to set those standards, because
No, it's an extension.
it's putting the setting of those energy efficiency standards entirely within the hands of national policies or guidance issued by the Secretary of State.
Yes, but you could have a situation, you could imagine, where the Secretary of State has got a policy which sets energy efficiency standard lower than the building regulations. Now, then you could say that cuts across the statute.
Yeah.
So, on that basis, there is a point to including those words in Section 1, because it makes it clear, amongst other things, that A, that's the purpose of the provision, and B, that a policy which purported to undercut the purpose by saying you can't, by setting a standard lower than the building regulations, wouldn't bite.
Well, a standard lower than building regulations would just be contrary to the statute anyway.
Exactly.
That's an improbable hypothesis.
Well, of course it's improbable, but it's a way of understanding what the statute is doing, that it's declaring, it's making clear that local authorities can exceed the building regulations. The words are not OTOs on the alternative construction.
Well, there's only so much time I can go around to subclauses of Section 1C. You've got my...
Well, I think we've got your submissions, and you've set them out very clearly in writing as well.
Yes, I mean, I do say this is a case where resort to Hansard, as the judge below did, is appropriate.
And the relevant bit is set out in the judgment, isn't it?
There's a relevant bit set out in the judgment.
Is there anything else we need?
Well, the Essex Planning Officers Association have set out have set out further bits, but I can ask the court to have regard to those without having to.
Can I just check? There are requirements in Pepper and Hart which we are required to follow.
Yep.
I had thought, but I must have misunderstood. Was this a private member's bill?
It was, yeah.
Well, why is this government minister, Sadiq Khan MP, why is he able to fulfil the requirements of Pepper and Hart then? Because I thought Pepper and Hart said the promoter of the bill, and the government isn't the promoter of the bill. It's just the largest party in Parliament saying what it thinks the promoter of the bill had in mind. I can't quite see. One, is it clear? Two, if it's not clear, according to Pepper and Hart, the statement has to be made by the promoter of the bill. Doesn't it?
Well, the promoter of the bill was Mr. Fallon.
Yeah, that comes from paragraph 53 of the judgment.
Yes,
Yeah.
which And in the back of the second bundle of authorities are all the Hansard references that refer to Mr. Fallon's comments. So, my lord, picking up on that point is where his comments are, which are of a kind with.
Well, should we not do it logically? I mean, am I correct, first of all, in thinking that Pepper and Hart says this court can only have regard to a statement in Hansard if it's A, unclear, and B, if the statement is made by the promoter of the bill? Am I correct on that? I don't know if you've got
Yes.
Pepper and Hart.
Yes, well, we've got Pepper and Hart somewhere in the second authorities. I think it's in the parliamentary authority.
I don't know if it might help, my lord, just to cut across this a little. The reason why ministers, there's two, Caroline Flint and then Sadiq Khan, become, and they succeeded each other, become relevant is because the section 1 was entirely substituted by government amendment during its course through Parliament. So the original bill was not supported by government.
But they proposed the clause 1, so that would meet the other requirement of Pepper and Hart.
Yeah.
Okay.
So he is the promoter of clause 1.
It remained a
Private members
bill, but it was one that was supported and indeed drafted by government in the present form.
There was a particular change, wasn't there, which is not actually relevant to this litigation. So this is covered in your skeleton somewhere.
I make various points in response to the Essex Planning Officers Association. There
where
was
I read
another amendment, that's irrelevant.
That's a different amendment.
But the first amendment is much more substantial.
Which was the introduction of a government version of section 1. Okay.
And I think on that basis, if we need to go to it, I would certainly submit that one could and should look at those ministerial statements to understand what those subsections mean.
Was there nothing like subsection 2 or to explain what is meant by section 116 in the private members bill before government came along?
No, it was a very simple creature, the private members bill, and even simpler in a way than one one's got there. It's only shorter. It's in the parliamentary bundle, as it's called, tab 45. This is as introduced.
Where are you? Sorry,
It's tab 45, page 219 of the parliamentary bill, parliamentary bundle.
Yeah, there it is. So we got a 1C, in fact, not even a subsection 2. So you got a 1C referring to an energy efficiency standard, but it hadn't been defined. So in a nutshell, you're saying the government introduced a definition?
The definitions, and indeed it's singular there, earn energy efficiency standards. So the concept of energy efficiency standards and the concept of energy requirements are introduced and only come into existence with the amendment. It was effectively a substitution of the operative part of the Act, what became the Act.
And do we have that amendment?
I think so. I think if you turn to the next tab in the bundle, tab 46, it was introduced
page
in committee
237.
237. What was that?
New clause 1, energy policies. So who proposed this then?
This was, I think, it remaining private members bill. This was, I can check this, but it may well have been proposed by Mr. Fallon, but one can see from the debate it was a government amendment.
Well, that's what we need to know. I mean, it's quite important. We can't just do anything in courts. We have to follow the law, and we need to know.
Well, on the next page, 238, Mr. Fallon invites members to vote against clause 1
against it,
and vote in favour of the new clause 1, which is the result of discussions he's had with the department.
And then one can see on that same page at the bottom, Mr. Fallon says a little bit, then he gives way to the Minister who talks about the new clauses at greater length. And insofar as one's looking, if one gets there and needs to look at Hansard extracts, in my mission, what the Minister says is of the same nature as a promoter of the bill, because it's government drafting amendments which the government is backing and is being justified by the Minister in this context. But maybe one doesn't get there. I certainly wouldn't say that what Mr. Fallon says becomes irrelevant, but I think what the minister says is relevant.
So often in these almost sterile debates about the use of Hansard, one's left wondering, is the minister any clearer than the legislation?
Unless there's anything else, I just thought I'd say why it was that we at least went to those passages, because I think we referred to them.
Mr. Goodman. Mr. Goodman.
So just take up the evidence in the supplementary appeal bundle, and if we just have a look at pages 44 and 45.
So out of the parliamentary bundle back to the supplementary.
Yes.
Yeah,
Yes.
of course. Page 45.
Tab 6.
Thank you. And this is
the evidence of Dr. Hugh Ellis of the Town and Country Planning Association.
Yeah, thank you.
And paragraph 16, he sets out under the heading the current approach to setting energy performance standards in local plans. And he sets at 16, the first policy option is based on the approach set out in the Written Ministerial Statement, which sets a percentage uplift to the target emissions rate using building regulations modelling tools. For domestic buildings, this is the Standard Assessment Procedure, or SAP. This approach explicitly does not achieve net zero homes. This is because the metric requires a minimum performance based on a number of factors, so it doesn't necessarily require high energy performance. It's dependent on grid decarbonisation to achieve emissions reductions, which is by no means guaranteed. And then he sets out the second approach is the LETI methodology of measurable energy performance, which sets absolute energy metrics expressed as energy use intensity and space heating demand for new buildings. And the impact of these is to force a building design that achieves highly energy efficient buildings. Now, the relevance of this, when we go back to trying to understand what the meaning of standards is that it's not as simple as the division that we as lawyers jump to of saying methodology on the one hand and what's the number, what's the percentage level on the other. The methodology encompasses an attempt to reach a certain level of energy efficiency. So,
are you saying the metric can be intrinsic to the standard, or part of the standard?
The energy efficiency level can be part of the standard. Yeah. So when you talk about which standard you're using, it's a bit more subtle and complex when you get into the actual detail of how they operate than just thinking methods versus levels.
So it could be a raw figure, or it could be a highly sophisticated formula or methodology to describe what's happening.
Yes. So that's what we say are the standards, which is it's a more technical and complex exercise than simply here's how you do it. And it's that which is standardised, whether you use LETI or TER, etc. by 1.2. That's what the Secretary of State can control in subparagraph 2 of section 1. The energy efficiency requirements of the building regulations refer more directly to the energy performance levels, how efficient you are. That's what we say.
That's leading to the second problem, that if the standards could include a raw type of figure or a sophisticated process for achieving a level of energy efficiency, if either of those is a standard, they're an energy efficient standard for the purposes of 11C, if they're fixed by national policies and guidance, because the only standards that are permissible under 112C, or the only things that are part of the things defined in 111C, are standards, energy efficiency standards, which are set in national regulations or guidance. You still come up against that.
Well, that's in my submission, that's an overly technical way of trying to make the legislation mean what the Secretary of State now wants it to mean in the WMS. What was intended by section 11C is that you can standardise the way in which these measurements are reached, and that can include standards as to what the measurements will be, which are then you then have to translate, because it's not directly comparable to the building regulations minima, but you can translate that to equiparate how much above the building regulations would that be. And that's
why did Parliament put in the definition in 1.2 then? I'm really concerned actually with Parliament. I'm not very much interested in what ministers and association people mean. I'm trying to work out what Parliament said. Why did they have 1.2, and why did they go out of their way to say it's a standard, provided it's a standard set in one of these ways?
Well, in my submission, one possible inference as to why that's there is that it standardises the proliferation of methodologies, mischief, which we see referred to at other times in the documents. So rather than have to go around each local authority, your volume house builder having to work out how to calculate it all again, once they've got their format unit, residential unit, and they know what efficiency it is, they know they're going to have one metric that they can use to apply in various different local authorities without having to redo the calculations according to some new complicated methodology every time.
Yeah, what you've just said reminds me that somewhere in the papers we're told that national house builders or regional house builders will often have house types, which they use in different development schemes, and which won't vary very much from one authority to another.
Yes.
So
so they have an off-the-shelf unit,
a conflict between that approach and different authorities having different standards.
Yeah. They may have options. They may have their energy efficient standardised unit, and they may have their cheaper version.
They may do,
and then they can plug in the energy efficiency one to the local authorities that set their own energy efficiency requirements, but they don't have to recalculate it according to some new complicated methodology every time. So that's what we say is the distinction between standards and energy efficiency requirements.
On a different topic, I just don't know whether you can answer this. We've been shown the first draft of the bill, and then we've been shown an amendment. And it's the amendment from what we looked at very quickly that added the words in 1.2. Are we able to look at the parliamentary history of the bill and consider what it was originally and the effect of the amendment in trying to work out what Section 1 of the Act means? Is that permissible?
Is that permissible under the Pepper and Hart?
No, under the principles of statutory interpretation that we're obliged to apply in this court because we're a court of law. The normal standard, you look at the wording of the Act in the light of its context and its underlying purpose, and having regard to legitimate aids to statutory interpretation. One of those is its explanatory notes, for example. Is the legislative history, i.e. the bill as it was enacted, as it was first put to Parliament and then as it was amended, are we able to look at the amendments as part of the legitimate aid to statutory interpretation? And I can look it up in Benyon, but in fairness, you should have the chance to say we can or can't if we're going to be influenced by that, because it looks as if 1.2 was added from what we've just seen, and 1.2 must have been added for a purpose. Anyway, think about that.
My preliminary answer is yes, which I'm going to check. Yeah. Yes, because where an amendment is made, it is part of the context of the statutory provision to enable understanding, put it in old-fashioned terms, what the mischief it's directed at.
You can certainly look at an amendment of earlier legislation.
Yes.
This is an amendment to a bill, is what I don't know.
Yeah.
But
I'll have to check whether there's any prohibition on that specific articulation of the what's permitted. So I'll look at that overnight on that specific point. So if the court gets to the position that we submit, that the purpose and effect of the statutory provisions is to allow local authorities to exceed the energy efficiency requirements of the building regulations in their planning policies, then you get to the submissions which I'm just going to refer the court to in writing, given the time. by which we say it's not then open to the Secretary of State to emasculate those provisions by the use of a national policy mechanism in reliance on section 1.5. But I don't need to...
We've got that from the Swish. Can I just ask you that? And does the written ministerial statement emasculate it? I mean, it obviously gives a steer, but does it prevent it?
Yes, so what we say on that is you have to look at the de facto reality of what the written ministerial statement achieves, and so it doesn't need to completely prohibit the possibility, but if the reality of it is to emasculate, and this is what the authorities say, I'm paraphrasing them,
Yeah.
then that's an impermissible use of the power, and that's in the both in Carla Holmes and the Palestine Solidarity Campaign, and we also say in the ex parte Birch Authority, and we cited all three of those for those propositions. Birch is the particularly close example. It's an old case, 1985 case, but we've cited that what the judge held, that it's quite unreal to suppose that a local authority would do otherwise than accept the opinion there of the Secretary of State as decisive. The present case is an example of exactly that. I've read the planning officer is advising his committee to do other than to approve the application will be contrary to the intention of the Secretary of State. So in practice, I'm quite satisfied that the procedure that's envisaged by the circular does constrain the local authority and does accordingly preclude local people from having a chance of making a representation. So in that case, the practical effect of the Secretary of State's direction through a circular was to cut the legs from under a statutory provision which was otherwise available, and that's the point on which we rely in relation to the impermissibility of the WMS.
Thank you.
Well, also, I'm very grateful. Those are my submissions on that.
Yeah, well, thank you very much indeed. Yes, Mr. Trimmins.
Thank you, Lord. I should say that the OEP is very grateful for the opportunity to make these oral submissions to the court. If I could just indicate to begin with how I'm going to use the up to 30 minutes available to me.
Of course.
The focus of the OEP is essentially a single but important point of statutory interpretation on section 19. The central point being whether the approach of the judge below, paragraph 44 of her judgment, that the duty under section 19 could be met by what she referred to as retrospective assessment was correct. In our submission, that was incorrect in law. That's the prime focus. That's really the point which set alarm bells ringing within OEP, and probably the key point that prompted.
Sorry, which paragraph did you say? 44?
Paragraph 44 of her judgment. That's in the core bundle, tab 9, page 139.
Thank you.
I think to deal with that, one has to deal with what's meant by due regard. I'm also very mindful of, I think I've got about 4 points that I noted down that were raised in argument this morning. Those I think were to do really, if I understand them correctly, with the practicalities of what the duty means, what does it actually mean to comply with the duty in certain circumstances. And I am going to come on to those. I want to reassure the court of that. If I haven't dealt with them in the course of my submissions, then I'll be sure I'll deal with them before the 30 minutes is up. So where I want to begin really is with the correct approach to interpreting section 19. And if I can just give my lords you don't need to turn it up because I think you'll be very well familiar with it. One of the many cases that the court will know on the Supreme Court on statutory interpretation, the case of Packard and Competition Appeal Tribunal. That's the relevant passage is in the authorities bundle at tab 25, page 678. and it's the judgment of Lord Sales, beginning at paragraph 40, talking about relevant interpretative principles. I'm not going to read it out because the court can quickly cast an eye over it and put a highlighter or a tab in it, but it's very clear that it's all about not just the words of the statute, but its purpose, which one divines from, amongst other things, explanatory notes and relevant parliamentary material. So it's a holistic exercise, if I can put it that way. We're trying to find the intention of Parliament from the purpose, the scheme of the Act, not just the wordings of the section in question, but how those words fit in with the scheme of the Act as a whole. So I don't think I need to say really any more than just to draw the court's attention to that. And there doesn't seem to have been in Mrs. Justice Lieven's judgment, so far as I can see, any real consideration of the purpose of the Act by reference to those principles. So what I'd like to do then is go briefly as I can to the relevant context and background, and I think have looked quickly at the explanatory notes, the starting point to the Environment Act 2021. That's in the authorities bundle at tab 6, page 98 in the bundle. If my lords have that, I just invite you just to cast an eye over paragraphs 17, 18 and 20.
There, I've got different bundles. Did you say tab 6?
Yes, it's in the bundle of authorities, the tab 6, and it's at page AB 98.
Thank you, yes, I've got it.
Yes, good.
Oh, it's after the end of the Act, yes.
It comes in, it's slotted in, doesn't have its own
tab.
It's after the end of the Act. So just have a quick glance at those paragraphs, if you would. So we can see from it that this provision came about as a result of a duty under Section 16 of the European Union Withdrawal Act. So this was part of Brexit and the concerns at the time of withdrawal and pre-withdrawal as to environmental governance, essentially. So we see at paragraph 18 the Act setting out measures to ensure there is no environmental governance gap now that the UK has left the EU. And paragraph 20, one of the ways in which that gap was addressed, it states, was by making environmental considerations central to the policy development process across government. So that was a real innovation, and without wanting to hype it up too much, one of the more important environmental provisions in recent legislation. We did put in then this additional materials little bundle, which I could then perhaps take you to briefly. So if you have that, there should be at tab 1 the draft environmental principles and governance bill. This is what the government introduced initially in response to that section 16 duty. And if you have it at page 5, you can see that there is the precursor of what is now section 19. Minister of the Crown must have regard to the policy statement on environmental principles when making, developing or revising policies dealt with by the statement. You'll note that that simply said have regard. It didn't say have due regard, as the current version does. And we can see from tab 2 that the formulation have regard aroused considerable concern amongst a number of respondents to the pre-legislative scrutiny exercise carried out by the Environment, Food and Rural Affairs Committee. So if one goes to page 12 in that little bundle, again, I won't read it out, but you can look at paragraphs 27, 28, 29 and 30. Various eminent academics Deputy Chief Executive of Natural England, Law Society of Scotland, suggested that this was a formulation which might mean that little or no weight would be attached to those principles. And there was a suggestion, in fact, that the formulation used should be act in accordance with, which is a very different kettle of fish in terms of duty. And indeed, page 14, the committee recommended that's what the duty should be amended to. Stronger wording of act in accordance with. That isn't, however, what the government did. It would have been a very tough duty if they had. What we can see what they did in the third tab, and this is the briefing paper produced by the House of Commons Library, analysing the bill, now the Act, considering when it was introduced. And in the last page in that tab, it's page 48 on the internal document reference, one can see effect of the policy statement on environmental principles. Clause 18 sets out the effect of the policy statement, and the government responded in that indented little section. We've strengthened the current duty from have regard to have due regard, with the aim of ensuring the policy statement is used effectively across departments. Strengthening the duty in this way means that ministers of the Crown will be required to give fuller consideration to the principles, as the policy statement will be given greater weight. We did check. We have checked that what the government actually said in the what's recorded at footnote 129 is accurately reproduced there. So that is what the government said.
So is this submission you're making that the EPPS has greater weight, that the statute has an effect on weight?
Well, perhaps I can go to that, because I think it's quite an important point. The Secretary of State in his replacement skeleton criticises the Environment Aid, the OEP, for saying that the EPPS has a different status to other material considerations, and says there's no hierarchy. Now, certainly I would submit it has a different status for reasons I'll come on to. Its statutory nature, the purpose behind it. Were it not for that statement, I would probably have said, well, weight is a matter for the decision maker. And there's numerous statements to that effect, for instance, in the decisions in the bundle on the PSED. Provided you have due regard, how much weight you give to what you've had due regard to relative to other things is a matter for the decision maker and a matter just for rationality.
There's a lot of case law on the same phrase, have due regard to the equality consideration,
yes,
in section
exactly.
149, and I forget who said having due regard means the regard due in the circumstances of the case.
Yeah, and that's I think the orthodox approach. But the word weight used there did just set me thinking a little bit. What was Parliament's intention here? And if you, of course, in orthodox terms, you go to cases like ex parte feuings, the weight to be given to a material consideration is a matter for the decision maker. They may decide to give little or no weight. I would, however, just question, in the light of that statement, whether, consistent with the duty to have due regard, a decision maker could choose to give the EPPS little or no weight. Would they still be having due regard to it? It may be the way in which one could look at it. Is this, that it does have to be given considerable weight because of its nature, its status, the way in which it's made and approved by Parliament. However, that's not to say that other considerations couldn't outweigh it. So perhaps it's not open to a decision maker to simply reduce the weight they give to the EPPS, but they could legitimately conclude that there are other considerations which, in the circumstances of the case, is going to carry greater weight.
But isn't this rather arid? We're looking at the words in the statute, not what Parliament committees thought or what library briefing papers thought. And they've used the word have due regard in a context where a similar phrase has been used for many years and has a distinct meaning. And she's that regard which is due in all the circumstances of the case. How that works out will depend on the circumstances of the case. And an arcane discussion over a senior common room table as to how much weight is due and so on. Does it really
I'm not, it's not a point I'm pressing too far, but my Lord Justice Holgate did ask me the question.
Well, I got the impression from your submissions you might be going down that road. Could I just ask, just so I understand this, you said there was a suggestion that the duty be re-expressed as to decide in accordance with the EPPS. Was that going to be absolute, or was it going to be qualified by expression like unless other circumstances, etc.?
Well, I don't know. That was simply the
reason
recommendation
why I asked
of
is that Section 38(6) of
Yeah.
the 2004 Act creates a presumption in favour of the development plan.
Yes.
You shall decide the application in accordance with the development plan unless, and
Yes.
the courts have said repeatedly, that does not loop and proved in the Supreme Court, that does not predicate how much weight is going to be given to the plan.
Yes.
So how can this lesser expression have that effect?
It's not a point
No.
It's not a big point central to my
No.
submissions.
Okay, but we've tidied that up.
You've tidied it up.
Thank you very much.
Thank you. So anyway, what I do take from this is that Section 19 is a provision which has both constitutional and environmental importance. It's intended to avoid a gap in governance as a result of leaving the European Union. I also note that the obligation derives in part from the Trade and Cooperation Agreement entered into with the EU, Article 293, which imposed a commitment to respecting internationally agreed environmental principles, including, in particular, the integration of environmental protection into the making of policies. That's in the Authorities Bundle, tab 36, page 944. One can then look, having looked at that background, at the scheme of the Act and where the wording fits into the scheme of the Act. And the one point I want to make there is that under Section 18, which the Court has looked at, the Environmental Principles Policy Statement has to be consulted on, Section 18.2, has to be laid before Parliament, Section 18.3. That, in my submission, must go to the status of the policy statement and the regard which is due to it, and that it's not simply another material consideration in a whole range. Section 19 we've looked at already. I don't think I have anything to add on that. But I would say that if we, I'm going to go on to some of the PSCD cases in a moment, but if we just pause there and take stock. My first submission would be that whether the Section 19 duty was complied with or not is a question of fact for the court to decide. Either due regard was had, quotes, when making policy, or due regard was not had. So I would not accept the suggestion of the Secretary of State that there can be a limited breach. It's either a breach of the duty or it's not. It either was complied with or it was not. Now, this perhaps then takes us to a point raised by my Lord Justice Lewis early on this morning. The policy is made when the development process ceases and the policy is in some way published. It's out there, it's adopted. Either there was or wasn't a breach of Section 19 at that date. If there was a breach, you can't cure that breach by any later reconsideration of the policy. The breach is there, and it comes then, in my submission, to a question of what the court does about it. It's a question of remedies. Given that there is a breach of a quite fundamental legal obligation set by statute, the starting point I would suggest is the court starts from the general position. The right thing to do is to quash. There may be reasons not to. That's the starting point. I don't think that's a controversial starting point, but if any authority is needed for it, there is the statement by Lord Justice McComb in the Bracking case.
I think he liked to be called McComb.
McComb, sorry.
I don't think much turns on it.
McComb in Bracking.
Yeah.
That's in the Authorities Bundle, tab 14, page 253.
Is that paragraph 26.4?
No, paragraph 69.
Well, there's quite a lot of authority,
Plenty.
authority saying that where a decision has been reached and there's been a legal error, normally you would quash it. But of course, it's
so
normally is the key thing.
Subject to two issues. One is the duty, maybe not to quash under section 31, 2A, and secondly the court's general discretion, which there may be reasons not to quash. So it's perfectly open, of course, if the minister has got it wrong first time round, to have another go, to look at it again, and that won't make what went before lawful, but it may have a bearing on remedies. And the point I'd like to make on that is not that one can't have an impact on remedies that way, but simply that the court does need, in the context of this particular statutory duty under section 19, to be quite cautious about that argument. That would be my submission. The reason it needs to be cautious is because what the minister would have been looking at, having another go, would be by definition a policy which would have been arrived at without EPPS assessment. The policy would already have been shaped, and so it may be difficult, not impossible, I'm not suggesting that, but it may be very difficult for the court to be convinced that that duty was complied with when one's looking at an already formed policy as opposed to one where the duty was applied early on in its formation.
And that would depend in part on whether anyone had taken any notice of EPPS principles in the development of the policy, as to which we had the appellant submissions that October was not sufficient.
Yes, exactly so, my lord, and that was the point made, I think, by Lord Justice Holgate. I mean, if there had been consideration in the development stage, but that simply hadn't found its way through to the minister on making the policy, then it might be very easy to rectify it.
Well, that's an interesting point you raise, because this is a duty directed at ministers of the Crown. But ministers of the Crown may well take the final decision, we can assume they do, but they don't do everything leading up to that decision.
No.
So presumably satisfaction of the duty is capable of being dealt with, particularly during the design developmental stages, is capable of being dealt with by officials according to normal constitutional conventions.
The way I put it is this, and it addresses, I think, the third point on my list raised by my Lord Justice Lewis. What does development of policy mean? So clearly the making of policy includes the development of policy. The person who is under the duty is the Minister of the Crown. The way I would put it is that the Minister, in having due regard subject to the duty, needs to be satisfied as to compliance with that duty in relation to the policy which she is making, and that must inevitably involve looking back and satisfying himself or herself that the duty was properly applied during the development of the policy. That surely must be the case, otherwise it would be a very hollow sort of exercise. And it's not, as I would say it's not, as was put in argument or in question, a case of the minister acting in a sort of judicial review capacity or marking anybody's homework. What it really is the minister satisfying her or his own duty, which may involve having to look back and satisfy themselves as to how the policy had been shaped or not shaped by reference to the EPPS.
Say there are 8 options in the early start. The ministers, civil servants get together at a hostelry close to Westminster and they discuss various options. And after the 6 Scotch options, 7 and 8 are quite dramatic. They get back to the office the next day and they think, well, actually, on reflection, 7 and 8 are really dramatic. And they don't put 7 and 8 in the policy. Is the minister, does she have to go back and check every stage to see that what options were considered? Were they assessed by EPSS? Did they overlook certain options? Although there were 8, there should have been 10. It's got to be an air of reality about it.
I agree there's got to be an air of reality about it. Indeed, the section itself builds in something about that reality, doesn't it, in the provision about not having to have regard if the benefit is very small.
But that begs the question, this is a procedure question, is how does she decide whether it's small? Does she have to go back and look at all of the initial options and also consider were there other options that they failed to do? It does sound a bit as if she's being turned into a legal supervisor. She's got to decide when she develops policy or when she makes policy or when she reviews policy,
yes,
which has got to have due regard to the EPPS.
Well, it's very difficult to be dogmatic, my lord, isn't it, and say that one's got to do this in every case. Clearly, it's going to depend upon the facts of the individual case. What I'm really saying is that the court, as with the public sector equality duty cases, does have to be willing to take a very hard look and a very critical look at what was done. That certainly comes out from a number of the Court of Appeal decisions which are in the bundle. And has to form a view at the end of the day, was due regard, which is a high standard of regard, had when making the policy. I'm not going to go as far as to say that you have to go back in absolutely every case and check each and every policy option, but what I am concerned about is the suggestion that you can just limit yourself to the policy options you happen to have ended up with.
Well, that's the next problem, because say it had been quashed and it went back to the minister.
Yes.
She would have to decide whether or not to approve the statement.
Yes.
Instead of that, they realised at the pre-action protocol stage, by the sound of it, that she hadn't actually, when she made it in December 23, looked at section 19 and the principles.
Yes.
And so, rather than have it quashed and start again, they decided to do the best they could. Now, I understand we ought to have been there. The civil servants ought to have advised the minister, and she ought to have considered it in December. But life is as it is, and she didn't. And if she's told, revisit the policy and have regard to the EPPS, and make sure you've actually complied with your duties under section 19, at the end of the day, where you are is going forward. You've got a set of principles and you want to be sure that the policy that you're revisiting, it's been adopted and it's been found wanting at one stage. Is it really the case you could only ever satisfy your duties as a minister by going back and reassessing all the options, including all the ones that have been discarded, possibly after a discussion by civil servants having regard to the EPSS, and do a full thing? Or can you not say, well, this is the document, this is what they say about that document. If I'm satisfied about it, you can go forward. If I'm not satisfied about it, then I can say, well, I'm sorry, I'm not satisfied.
Well, just one point initially, my lord. You said possibly after consideration of the EPS. Now, that's an important point because, of course, if somewhere along the line there had been adequate consideration of the EPPS,
if the
you don't have to go back beyond that in my submission. You can take that as your starting point. But I think the risk is what's required by section 19 is not an exercise in environmental impact assessment of policy. It's not looking what are the upsides and the downsides of this policy from an environmental point of view. It's something very much more radical, fundamental than that. It's actually trying to ensure that, as we've seen from explanatory materials, that the EPBS is actually embedded in the policy-making process, so to have a reasonable chance of shaping that policy. Now, I'm not going to get involved in the facts of this case, because that's not our role. We're not urging one outcome one way or the other, but I would just invite the court to have a look at what Green Lion's written submissions say about this. That's in the core bundle at tab 5, pages 100 to 101, and paragraphs 50 and 51. Now, I emphasise I'm not adopting those submissions because we're not getting into the facts, but it does set out, I think, quite neatly the point that there were in fact two sets of submissions in April 2023 and July 2023. The duty then wasn't in force, but there clearly were some options on the table which would have had the effect of encouraging and providing a framework for local authorities to go further. Ministers decided against that in April and July, but in my submission it wouldn't necessarily be unduly onerous to say that the duty would involve going back and reconsidering those decisions. I'm not making any statement on the facts. I'm simply saying that one can come up with circumstances where there may well be a sensible approach to going back and looking to the history to a certain extent. I can perhaps deal with the, while I've got it, this is my last...
You said a second ago that this isn't like EIA.
Yeah.
We do have the SEA regulation.
Yes.
Which require a range of environmental factors to be considered in a report as part of the process of formulating policy.
Yes.
Or programmes. Those criteria are fairly specific.
Yeah.
Would it be fair to describe the EPBS as a fairly high-level approach to integrating environmental considerations into the making of policy?
I think that almost inevitably goes with the nature of policy and the nature of the principles. They are, in their very nature, higher level principles. That's not to say they're not important and can't have a real impact on shaping policy. But yes, it's a much higher level exercise, I would suggest, than SEA, which involves a very structured process, as my Lord will know, of identifying particular types of environmental effect. If I could just deal then, the final point, which I think was the only one outstanding on points raised by my Lord Holgate, was on the retrospective issue. So what happens if policy is in the course of development when the duty comes into force on the 1st of November 2023? As my Lord correctly identified, there are no transitional provisions. So the Section 19 duty takes full force and effect from the day it comes into effect. There is nothing to provide any transitional relief, as it were. But if one takes...
Relief or application?
Yeah. A hypothetical example, I can give this. Let's say you had some area of policy which wasn't obviously to do with environment, and nobody realised prior to November 2023 that the duty was going to apply to it. And that policy had reached quite an advanced stage of development. No consideration had been given to the environment in any way, shape or form. And it was clearly apparent that the policy was going to have the most horrendous environmental effects. The duty then comes into force. The minister comes to look at that policy by way of adopting it and is subject to the Section 19 duty. Now, in that circumstance, is it open to the minister to say, this policy was developed up until the point the duty came into force. I have to take it as it is, and I can only apply Section 19 in relation to any changes or amendments or tweaks made to the policy after the 1st of November. My submission is that would be a very ineffective approach to applying Section 19 duty. I cannot see that that is what Parliament would have intended. So,
but if the policy had been published the day before, that's precisely what the position would have been.
It is.
And if they are waiting for a few days for a couple of ministers to write back in, it's quite an interesting question as to what happened. And a lot of this case seems to be a desire from the moment you get out of bed to make sure I'm thinking about policy, I must put it into the policy formulation stage. But the policy development stage is meant to lead to a set of policies that are environmentally aware. And obviously, if you don't think about it as you're going along, if you don't consider possible alternatives, then there's a risk that you miss something. But it seems slightly difficult to say, at each stage there has to be a full, because again, what's due regard may well differ, may not be the same at each and every stage.
No, plainly not. So that I think hopefully has dealt, at least to some extent, with the points raised. I do just want to deal with the reliance by the judge below on the case of Rowley, because that clearly
you're straying beyond your 30 minutes, but of course,
sorry.
Yeah, no, don't worry.
I can deal with it very, very quickly, I think. So Rowley, she refers to that and says Rowley, that's paragraph 43
Thank you.
of her judgment. I don't think we need to look at Rowley, actually. It's a very long decision to do with essentially the COVID briefings, which we all remember being given at 6 o'clock in the evening, and the provision or not of adequate sign language.
Sorry, paragraph 44, I think.
44, I'm sorry.
Yeah, because 43 is HOTAC.
Yeah, I'm sorry.
Yeah, no, don't worry. Yeah.
44. So in Rowley, that's I think it's in the authorities bundle, page 619. I think it actually, yes, it's in the first.
This was the sign language one, wasn't it?
Yeah.
Yeah.
There were two issues in Rowley, but I'll deal with it very briefly in this way, in relation to the briefings. One was a failure to provide adequate consideration of the PSE duty in relation to two specific briefings which had occurred. It had been unlawful. There was no attempt to cure it. But secondly, there was allegedly, as a separate matter, an ongoing failure to provide what was called on-platform interpreters versus in-screen. So somebody standing on the platform is supposed to be in a little box on the screen. And you can see at page 590 in the bundle, those two questions set out in italics, paragraph 17. So the question 2 was the ongoing duty, and the learned judge in that case considers the public sector equality duty in relation to the second scenario of ongoing breach at paragraph 38. That's page 612 in the bundle. The heading in relation to the on-platform, is there any present and continuing breach?
Sorry, paragraph?
Paragraph 38.
Sorry, thank you.
Yeah. And then over the page, page 613, paragraph 41, you can see it was submitted that whilst there had been later consideration of PSC duty, it was too little too late. And what the judge rejects that submission, even though the assessment had come in at the 11th hour and 59th minute, as it were, before the deadline for the relevant skeleton argument. That just about was okay. But the point I'm making is that was consideration in the context of an alleged current ongoing breach. And in the context of a current and ongoing breach, well, plainly producing something late may well have a legal effect. The judge was wrong in our submission to apply that to a situation of a completed breach, which had occurred at the point at which the policy was adopted without compliance. Now, I think I've said more or less all I want. Can I just deal with 2 minutes, just one point?
Of course.
Thank you. And that's the importance of clear records. One thing which was heard from the discussion this morning, I think, is the difficulty of trying to make sense of inadequate written records of what went on as part of this process. And it would be very helpful in our submission if the court could make clear the desirability in compliance with this duty of decision makers making clear and complete records, recognising that's not a legal requirement, but is a matter of good practice. And if I could give an example of that before I sit down, of that argument being made or that guidance being given by the court, that's in the case of CAO and Secretary of State for the Home Department in the authorities bundle at tab 27, pages 802 to 803, in the joint judgment of Lord Sales and Lady Keegan, Lady Chief Justice, paragraph 82 in the judgment. In the law report, it's page 874, G to H. That emphasises it's good practice to record reasons. And
if they've done it, do we need to do it as well? I know they've done it in the PSED, but what we would say would certainly not have the resonance of Lord Sales or Dame Siobhan.
Well, what I'm saying, my Lord, is it wouldn't come amiss to say the same thing in relation to the Section 19 duty, given that this is the first time one of the higher courts has come to consider that duty. So, my Lords, I'm sorry I've gone slightly over, but...
Don't worry, and thank you very much, Suzanne. Thank you very much indeed. Yes, Mr. Westwood.
Well, Miles, I have a number of points, and I wonder, looking at the time, whether it might benefit.
Entirely up to you. You can give us 7 minutes of both barrels, or you can wait until tomorrow morning.
Well, I may be able to think about which barrels to empty or recharge a little. So I think, given that we have 2 days, I suspect we won't need work tomorrow morning.
I agree with that. So you'd rather start tomorrow? That's absolutely fine. Good. Well, thank you.
The only one thing I had was an additional authority of Synergy that would be well known to the court in the event, which you have the recent case of Westfields, but I've shared this with my learned friends. I think it might be useful to have Synergy as well.
Well, do you want to hand it up now? Because then we've actually got it rather than it getting lost in emails.
Are you citing this because it deals with the consequences of a failure to comply with it? I think we have even more authoritative.
Well, I think you said Westfields, but I think you meant Greenfield.
I misheard. It's A1.
In the Isle of Wight case.
Thank you very much.
There's
A1 in the Supreme Court.
There's A1.
There is A1 in the Supreme Court,
which helpfully explains Synergy.
Yeah, I'm happy to. That's quoted more extensively in my Lord Lewis's case of Greenfield, so I didn't think that needed to go before the court.
No, it's in bundle, I think, but I don't think it matters.
Anyway, we've got Synergy now. Thank you very much. Is there anything further before we rise? No. Well, thank you all very much indeed for all the help, and we'll look forward to seeing you for a 10:30 start tomorrow.
All right,